Next up is Shahid Buttar, who most of you know as the Executive Director of the Bill of Rights Defense Committee, but who more recently has assumed the Executive Directorship of the People's Campaign for the Constitution, involving, as I understand, a lot of local action. People outside of Berkeley, actually, foreigners in this country who feel strongly about these things. And when you're an executive director, that means you make things happen. That's what Shahid is doing. Let's welcome him tonight.
So I'm going to talk about a couple things in particular to follow on what Marjorie said. Just first, a quick shout out to the Guild for any law students here. The National Lawyers Guild was the first integrated bar association. It was founded basically so that black lawyers would have somewhere to go when the rest of the profession still formally discriminated according to race. And it's continued that laudable history ever since. The particular frame for my remarks, I'm going to focus on the suppression of evidence in particular, locate that in a couple different procedural points. We'll talk a little bit about legitimacy, both in the context of the torture issue, but more broadly and how it unfortunately blows back into the legitimacy or lack thereof of the criminal justice system generally. We'll talk a little bit about action opportunities, and then depending on how the time's going, I might kick a rhyme one time before I sit down. The overarching frame, think about legitimacy, right? The legitimacy of justice depends on the consistent application of neutral rules across differing facts. That's what is supposed to differentiate law from politics. Not to give away the ball game here, but we're going to talk a little bit over the next few minutes about how, on the one hand, our criminal justice system imprisons 2.3 million Americans for essentially innocuous behavior with no third-party impacts, right? Non-violent, consensual behavior that is criminal only by dubious acts of legislators. On the other hand, you see a cadre of people, numbering in the tens, former government officials, all powerful people, who have enjoyed immunity for grievous acts that are criminalized not only in the United States, but in every jurisdiction across the planet. And the unequal system of justice, impunity for powerful people who violate grave laws versus the relentless and vicious prosecution of powerless people who violate laws that have dubious legitimacy in the first instance, it sets up a tension that erodes the legitimacy of the criminal justice system as a whole. So I invite you to consider torture and impunity for it in a broader context. Right? I mean, it absolutely makes sense to talk a lot about John Yoo given where we stand here today, but realize there are much broader principles beyond the individuals that are implicated. And there are principles that should matter to you as people who are studying the law, because whether or not the law has any legitimacy going forward turns to a great deal and a great extent on how we as a country deal with and resolve this regrettable episode with torture in our midst. And so let's talk a little bit about facts. Where are the facts on torture? We know that there are thousands of photos, there are videos, there are memos, at least 92 tapes that we know about in addition to others. And we know that many of those tapes, in fact the vast majority of them, were destroyed. The investigation that Marjorie referred to, the one that the Justice Department is pursuing at the moment by prosecutor John Durham from Connecticut, is a limited investigation. It started with an investigation into the destruction of the tapes and the destruction of that evidence. It has since expanded into a very still narrow investigation into the acts of the junior level CIA agents who exceeded the approved techniques. Let's just note what that means. If we're only prosecuting the people who exceeded the approved techniques, we're essentially conceding the legality of the techniques that were approved. And note that we're not going after the decision makers who are most culpable for the acts. We're going after the most powerless people in the bureaucracy. Now, I don't want to give certainly CIA agents who threaten detainees with drills to their heads any kind of cover. But if we're going to locate culpability, think back to Nuremberg in World War II, right? The idea was that liability goes throughout the chain of command, and it's strict liability, right? You commit the act, you have committed a violation. There is no defense. Now, just note, then in Nuremberg, the controversial principle was whether or not just taking orders constituted a defense. Let's contrast that with where we're at now. Today, it is no longer the case that just taking orders has been ruled a defense. In fact, just writing the orders has become the basis, not just as an affirmative defense, but for wholesale immunity from even mere investigation. There is no investigation, even, into the acts that approved wanton, systematic, and recurring violations of human rights principles that are shared around the planet. I won't dig too far into Marjorie's closing comments, but note also that these acts were not only illegal, but demonstrably harmful to US national security, both in the narrow sense that we're gaining bad intelligence and in the broader sense that we're basically giving terrorists talking points to recruit suicide bombers to carry forward the next wave of attack. Last fall, after 2 courts ordered the release of the evidence, the photos and the video that was not destroyed by the Defense Department, the Obama administration initially declared its intent to comply with these rulings. Sensing the danger to its interests, the CIA, embodied in its 5 most recent heads, wrote a letter to the Obama White House last October. I guess it was about a year. Within a week of receiving the letter from the 5 most recent heads of the CIA, the Obama White House managed to successfully secure an act of Congress, amending the Freedom of Information Act, which was initially introduced and passed the last time there was a grassroots victory in the face of executive secrecy, to give the Defense Department the authority to, on its own whim, hide evidence of its own criminal trail. That's where the law stands today. The Freedom of Information Act was amended by Congress to allow the suppression of evidence that remains secret. So I would invite you to consider what legitimacy impunity has when the evidence of the underlying crime remains secret to you, I, the public, the press, Congress. No court has ever seen it, and prosecutors don't see it. There was an Office of Professional Responsibility report this spring in the Department of Justice assessing the extent to which I'll just sum them up as torture lawyers, including not only John Yoo and Jay Bybee, but a raft of others, David Addington, who was essentially the architect for many of the Cheney policies. There are others, John Rizzo and the CIA. I would say if you put them all together, there may be 30 or 40 of them. Many more than the names with which you're casually acquainted. Realize that it stretches beyond particular individuals. This was, at least within the senior ranks of the administration and the Justice Department, and the Office of Legal Counsel in particular, a systemic problem. The DOJ investigation by the Office of Professional Responsibility never even purported to assess whether or not there were criminal acts committed. That wasn't the focus of the inquiry. It was just an inquiry into the ethical potential violations of the torture lawyers. And you'll recall, if you've studied it already or you'll learn soon, about the duties of care and competence that lawyers are mandated to abide, as well as the duty to remain free of conflicts of interest. The last thing I'll just say on the OPR report was that while investigating the ethical potential violations, the lawyers who were subject to that investigation had an internal appeal right and essentially rewrote the report. The initial version of the report, we know, concluded that there were intentional acts of professional misconduct. The final report essentially absolved the lawyers of all of that, claimed that there was merely poor judgment, whether evaluated in the context of their competence, in the context of their illegal acts. We know that there were gross violations of professional competence. Looking again at the suppression of the evidence, I just invite you to consider the legitimacy of the outcome so far and to expand your analysis and look at this in the context of the broader justice system, of which, unfortunately, accountability for torture has yet to become a part. Thank you.
So next up is Andy Worthington, and I can't tell you enough about Andy Worthington, so I'll just say a couple of words. He's a very prominent British journalist, a writer, author, filmmaker, and he knows more about what went on in Guantanamo than anyone I know. He has had personal interest and, in many cases, contact with 450 of the persons in Guantanamo. That's more than half, okay?
Thank you very much, Ray. Hello, everybody. I have traveled a very long way from London, as I hope you can tell from the accent, specifically to be here. The famous Bolt Hall, the famous home of the infamous John Yoo, and it was important enough for me to travel all that distance because this man really was one of the prime architects of the torture program that has done so much to disfigure our moral lives over the last 8 or 9 years. I believe, I've done so many events during this week, but I believe that this one is called Torture and the Law, Torture and Human Rights. Is that correct? Yes. When I started my investigations about 5 years ago into the Guantanamo prisoners, I didn't really know that much about the law. I'm not a lawyer. I didn't know that much about torture at the time. I think I was pretty clued up on the fact that human rights violations had been taking place. I was interested in Guantanamo. I'd been interested in it from when it first opened because there was something fundamentally wrong with this prison that was so notably outside the law from the moment that it opened. But I began researching the stories of the prisoners in Guantanamo to find out who they were, mainly through publicly available documents that the Pentagon was forced to release after 4 years after the prison opened, and to go through all those documents that contained allegations, that contained transcripts of these very unfair tribunals that had been held at Guantanamo in 2004 and 2005, which were very one-sided. The prisoners weren't allowed lawyers, they weren't allowed to hear the secret evidence against them, and they weren't allowed to know who had made allegations against them at all. But many of them told their stories, and that enabled me to paint pictures of these people, to draw their stories together and to tell them to the world for the first time, which I did in my book, The Guantanamo Files, and which I've continued to do through my journalist. Now, there's been a constant counter-narrative against this notion that there ever was torture at Guantanamo, or anywhere in the War on Terror for that matter, despite the existence of the Abu Ghraib photos. They're usually pointed at as the few bad apples scenario, and there are people who try to argue to this day that no torture has taken place at Guantanamo. Well, that's a ridiculous thing to say. I mean, the one particularly good reason for knowing that that's not the case is that there was a prisoner at Guantanamo called Mohammed al-Qahtani. Now, he was presumed to be the intended 20th hijacker for the 9/11 attacks. And when his identity was discovered, the kind of torture techniques that were approved by John Yoo, Donald Rumsfeld took hold of aspects of this program and decided that he would apply it to Mohammed al-Qahtani in Guantanamo. And over a period of about 3 months, he was subjected to extreme sleep deprivation. So in general, he was only allowed 4 hours sleep in a 24-hour period. And he was constantly humiliated and abused throughout that period until the FBI reported that, that he was very seriously losing his mind. And just before Bush left power, I still find this quite extraordinary actually, but a protege of, close friend of Dick Cheney and of David Addington, Susan Crawford, who was the convening authority for the military commission trial system at Guantanamo, did an interview with Bob Woodward in which she explained why Mohammed al-Qahtani, who had been put forward for trial by a military commission, why she had refused to press those charges. And she said very simply to Bob Woodward, "We tortured al-Qahtani. We tortured him. The legal definition of what we did to him was torture. We crossed the line." In looking objectively for the first time at information that's not publicly available to us, interrogators' reports, stories from the inside, what they have been discovering over and over again is that what the government claims is evidence is actually information which is derived through the torture or the coercion of other prisoners or of the prisoners themselves. And this has just been emerging regularly in these cases. I think I'm disappointed that these cases have not been reported enough in the mainstream media over the last 2 years. Some of them bubble to the surface every now and then, but it's an ongoing process, and all of it is fascinating, and it constitutes, I think, a very large and contemporary body of work coming from the judiciary that provides a very, very sharp and focused insight into the actual extent of the torture program that was initiated by the Bush administration, many of whose victims are still languishing at Guantanamo. So, thank you.